Good afternoon. Just to let everyone know who didn't see it, it looks like the recording of the event has started. So just letting everyone become aware of that the recording started.
Alex, how are we doing in terms of amount of people on?
Still waiting for a couple more. Looks like we have about 17 in. Maybe if we could wait another minute or.
Okay, great. Thank you. Okay, I think we'll get started. Thank you, everybody, for being here today, and again, for all the work that you're doing. A couple of logistical things before we get started on the substance. Joette, my understanding is there was a notice that went out that talked about a subcommittee meeting for the 23rd. Do you want to explain what's going on there?
No, thank you. Yeah, we have no idea how it happened, but apparently after our last subcommittee meeting, an invitation went out from me, which I didn't send, to everybody, identifying, I think, November 23rd as a date for a meeting of the entire group. One, it's not my place to do it. Two, I'm incapable and incompetent to do it. And I have no idea how it happened. But I've been getting lovely responses from people for the last 10 days. And I'm so glad that you're all available, except there is no meeting. So basically, to quote Emily Latella, for those of you who are old enough to remember her, never mind.
Thank you.
Thank you.
So I'm going to remind everybody, if you're not speaking, please put your volume on mute. And I'm going to start by saying this may be a little bit fluid today. We're going to assume that everybody did get a chance to at least read through the legislative proposals. In an ideal world, we would be able to have discussion and then make any amendments and or have some additional information for the rationale if there are some people who don't persuade the majority, or if we think that it doesn't need to go back to the subcommittee for them to rethink through some of the discussion items today. We'll try to get approvals. The reason we want to do that is the external affairs folks at Judicial are finalizing the package that they want to give to the Chief Justice and Chief Court Administrator for them to start reviewing. So the sooner we can get on that agenda, the better. Having said that, we want to get it right. So if we need to slow it down, we'll figure out exactly how we're gonna do that. So that's the goal today. And as I said, we're going to assume that folks, in the interest of time, that folks did get a chance to read the materials. But at the same time, we're going to ask one of the chairs to give a very brief overview, and then we can have discussion and see if we can get a vote on the various proposals. So if that works for everybody, we will start with the Data, Statutes, and Rules Subcommittee changes to 51-232 proposal.
Thank you, Chief Justice Tim Fisher here, reporting on behalf of Claire Howard as co-chair and myself and our subcommittee. So we have submitted a proposed revision to subsection 3 of General Statutes 51-232. And our goal being to enable the development of a database of information that would enable the branch and researchers to assess at what stage of the jury selection process, from the very beginning of this, when the summonses are responded to, all the way through when the jury begins to sit, at what stage do we lose people who would make the juries more representative of the under. So we have proposed alternative language that subsection C of Title 51-232, the only revision to any statute or practice book we think is necessary. And the revisions that we propose would, number one, provide for quite robust record keeping of the characteristics of people who are summoned and then eventually selected for jury. A record of where along the way they are lost, so to speak, whatever the means or reason might be. Information about their characteristics left within the judgment of the judicial branch as to what demographic characteristics would be recorded. Obviously, race is the factor that launched this task force, but other characteristics could be of concern over time, and so that would be in the discretion of the branch. Personally identifiable information would be kept confidential, but the generic information would be maintained available in a database for the branch and for researchers to examine. That's the proposal. There are two alternative ways of phrasing it that we have supplied. The second one would be all new language that is, if we were writing it from scratch, that's what it would look like. But we also supplied an approach that would basically preserve so much of the existing subsection C as is possible and add a few portions and detract a few portions, on the expectation that the external affairs folks might believe that would be easier for the legislature to digest, more familiar to be an adjustment to an existing statute than a rewriting. The second half of our work has been developing recommendations on how this would be implemented, and they will be as part of the new jury management system that is currently in development through a series of software and maintenance plans of the branch. The goal would be that juror information forms would be machine readable and can be prepared online by the juror, but also on paper if need be, but in machine readable paper like our ballots, if you remember. The goal would be to record every stage at which somebody no longer stays in the process. It would be recording both peremptory challenges, which of course was the trigger for this task force, but also challenges for cause and any other factor that causes us to lose jurors in case we can find that there is a racial disparate effect there. And then finally, keep the records, the information in accessible open access plan, as that term is used in the general statutes. So the theory behind this is to identify when do we lose people that cause our eventual juries to be non-representative. And by getting a robust database, we're able to facilitate the kind of inquiry, both internally and externally, that enable us to figure that out and ascertain whether this is a institutional failure, whether it is a socioeconomic issue, or whether it is the behavior of trial counsel or others, and really zero in on that. And also be able to provide feedback to the trial bar. What our recommendation is that when a challenge or a peremptory challenge, either one for cause or peremptory, is made, it be recorded what lawyer made that challenge, and in deciding which lawyer to ascribe it to in the event of a team, it be ascribed to the first chair, trial counsel, on the theory that that person is most likely the decision maker, and that person is in a sense accountable for the conduct of that team. And we have seen, and I'm wrapping up now, we have seen in the model of this algorithm that Professor Sachin Pandya prepared for the federal prosecutors, we've seen how powerful it is in being able to provide an individual lawyer by name. Here's feedback on how close to neutral your exercise peremptories are or aren't. And that's fascinating information. It's highly specific and useful information for an individual to know about what the pattern has been of their effect on jury selection. That's it on ours. I'll just say that the proposal of the jury summoning committee subcommittee, which also relates to 51-232, we've looked at that and we see it as consistent with our proposal. So the two can go alongside each other without any conflict or meaningful overlap as far as we can see.
Thanks, Tim. Okay, discussion, questions, concerns.
No, I had my hand up, so I guess.
Oh, I'm sorry, Harry. I can't
Yeah.
see everybody, so just jump right in. I can only see certain people.
Okay, consider me jumped. I just had a couple of questions for Tim. Number one, reading this over, I get the impression that you're going to let the judicial department develop how best to make the form so that it gets the information in the best way as the best time possible. You're not really dictating when the form is sent out or how that data is gathered, just that you want to make sure the data is gathered.
Exactly. Our thinking is that partly because technology changes over time, and partly because the discretion can be varied, and actually the kind of characteristics we want to, just the stages of jury selection itself. All those things are subject to change over time. We can't predict those, but having them locked into legislation, we think could slow down the ability to accomplish the real goals.
Yeah, well, looking at this, because I think that's a great way of approaching it, because I know that what New York has done has made a mechanism for a separate form, or a form that runs away from the names. And by giving the freedom to do that, you might get actually an answer on one form that is nameless and not get an answer on the form that actually goes to voir dire if everything is explained, for various reasons that we know. So leaving that freedom is good. The other thing is, I noticed you don't make any change or suggestion that people have to answer the race question. Is that correct?
We don't say so. We would expect that the plan would be for the judicial branch to require it. But there are other characteristics that at present, for example, gender identity, that judicial might conclude that it doesn't want to mandate, but might over time. And so we think that that's also subject to evolution.
Good. Thank you, Tim.
Tim, this is Dan Krish. First of all, great work. My only question is about ascribing everything to the first chair. There is some case law under Rule 3.3 that, and I can't remember the name of the case, I do know Justice Katz wrote it, if that helps, that being an associate doesn't get you off the hook if if the first chair is the one misrepresenting something to the court. I'm just wondering if that plays in at all, and to what extent that should matter, that a lawyer can't evade their ethical responsibilities just because they're not sitting in the first chair.
Yeah, that's a great point. Fortunately, Justice Katz wrote so few opinions, so I think she can help on this. But our thinking was that it's hard to know exactly who to ascribe it to if there are three people in the room. And so having some difficulty monitoring actually who to say is the person, we thought could be a problem. And so, and could require in a civil case, for example, that there be a clerk in the room to monitor who's actually filling it out, as opposed to having it be automatic. And so for implementation purposes, but especially for motivation purposes, we figure that if the first chair is responsible, then that person will be incentivized to send the message to the whole team that, folks, we're going to be really careful about this and we're going to be neutral.
Thanks, that makes sense.
Anybody else? All right, Tim, I just had two questions. And the first one's, I guess, a follow-up to what Harry was saying. If we were to go with the rewritten version, which is the second one, it was a little vague to me, but maybe that's how you want it, because what it doesn't really say is they're going to develop a separate record of such information that will then provide the information that we want. So I didn't know, was that a conscious decision to do that?
Yeah, so you heard me say in implementation that there ought to be an open access plan, as that term is used actually in Title IV of the general statutes. That I think was implicit and we didn't spell it out. I think there are pros and cons, and I'd be happy to talk to our group about tweaking it to make that explicit. Clearly, it's the intent of our group that the data be available to researchers both inside and outside of the branch. And so to make that possible, then there has to be a publicly accessible database.
Right. Okay. So this is just a suggestion if you all want to talk about that, is that in the second version where it's the 1, 2, 3, 4th line in, also be sufficient to develop a separate record of such information that the judicial branch determines. Good.
All right. We'll consult by email with our group. We're meeting again on Wednesday. So if we have a suggestion for a late edition, we'll submit that quickly.
Okay, and then the only other question I had was when I looked at actually the next committee's suggestions, and they had all of the original C. There was a lot of other information, not a lot. There were several other things in there, like explaining to the potential juror why this information was being collected, which seems beneficial to me and makes sense. And I just didn't know whether this is just a piece of what C is going to look like, or did you intentionally take out that additional substantive information?
We intentionally took that out, thinking that the judicial branch should decide how to craft that rather than the legislature.
Okay, so that it kind of implies we're not suggesting to them you shouldn't do that anymore.
Correct. And we're preparing a set of recommendations alongside this that will be following from our subcommittee, and that it will spell that out.
Okay, great.
And might I add
And
that
I'm sorry, just one final thing. Are you looking for guidance today as to whether people like the first version or the second version, or is your game plan to provide both and the branch will figure out what to do?
The latter.
Okay. Okay. Anybody else?
Yeah, I just wanted to add.
No, go ahead, Harry. I'll defer.
Oh, thank you, Joy. It seems to me that even with a lot of these legislative proposals, the follow-up between now and when we finish would be some of the practical recommendations to help implement them and make them work that we don't want as part of statutes or regulations, but we just want within the process itself. So that's what I liked about this, is that it leaves that flexibility to make it work most efficiently and most effectively to get the information you want when you want it. Get the information at the right time.
Okay, great. Joette?
Okay. I have a question, but the case you're talking about, I think, is Schatz and Schatz, and the lawyer was Carolyn Carvello, but I can't remember who the other party was, so forgive me. And thank you for the deference and compliment. The question I have is about the unintended consequences of this, or maybe there are intended consequences. One of the things we talked about in our group was, which is the Batson group and reworking it, was the question of somebody's history of inappropriate or repeated use of peremptory challenges. And forgive me, Harry, but the question came up largely around prosecutors and repeated use, and we were thinking about the concept of prosecutorial misconduct as a sort of a template and a repeated history or a pattern of behavior, not exclusively, but since that's where the bulk of trials go on, certainly in criminal trials, and obviously being conducted by prosecutors, that was an obvious target, and I don't use that word intentionally. So my question is about the potential use of this, because one of the things that we put in our rule was, if in fact it's known to the trial judge that the particular attorney exercising peremptory challenges has a pattern of behavior around this. And again, we tried to make it as tight as possible, that it wasn't going to put a burden on the trial judge to go out and seek information. It wasn't going to be by innuendo. It really was going to be concrete information that the existing and current trial judge had. Is that the kind of thing that you can envision this being used for? And I just ask you to speak on that if you don't mind.
Yes, I could envision it being used at several different levels. One would be individual lawyers would be able to access that kind of information, and especially if an algorithm like that of Professor Pondius is made available, then anybody can look up and see how he or she themselves have performed over time, and it might be useful feedback and cause them to adjust their behavior on their own volition. It could also be available to the judicial branch in case it gets word of alleged conduct by somebody checking whether it's actually a pattern. It could be used in the case of criminal defense counsel. It could be used as a new form of Batson challenge to a particular exercise of peremptory by a prosecutor. And then I imagine it just on a broad social basis, if somebody were studying national trends in jury selection, it might show where Connecticut, how we're doing compared to the rest of the country. And this could be a model for the rest of the country also to follow in monitoring their jury selection processes.
Thank you for the explanation. It's terrific. I appreciate it.
Anybody else?
Yeah, I just with that addition, I think what you're going to probably find once this is disseminated to the bar is that there'll be more objections, Batson objections made by prosecutors, those that are let go now, but they'll just make more Batson claims, which isn't a problem. I think that's a good thing. I think it sheds light on the process, and any light is a good thing.
And that was going to be just what I raised to Chief Justice, that to Dean Fisher, it's also defense attorneys, not just prosecutors, right? We're hitting both sides.
Yeah. Thank you.
Okay. Tim, so, with the possible change of adding a little language to make it clear that there's going to be separate public information available, do you feel then that we should vote today? It sounds like we're pretty much on the same page, at least based on the questions, to see whether people approve it.
I'm comfortable asking any members of our subcommittee. Judge Abrams, I see others are present. If anybody else has any concerns before we put it in your hands. Great.
Okay, terrific. So can I get a motion to approve the proposed revisions to CJS 51-232?
So moved.
Thank you. And a second.
I'll
Second.
Thank you.
All right. All in favor? Aye.
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 Anybody opposed? Hearing nothing, it's approved. Thank you very much. All right. I think we can move on to the juror summoning process. And who's going to be speaking on that today?
What I've what Esther and I have hopefully planned for your review is to have the people who have drafted each particular section to present it and answer the questions. Of course, we've all reviewed these. The comments tell you how these were passed and considered by the subcommittee in general, but I thought that we should have the people who drafted them to go through each section. So the first section, 217, I think Eric Lohr or Jim Healy will be speaking on that, and you can ask them questions, and of course the rest of the committee can supplement that as necessary, if that meets with your approval.
That's fine. Yep.
Okay, Eric.
Okay.
Thank you, Harry. So we were looking at changes to two statutes, only one of which ultimately has recommendations for changes. That would be the Connecticut General Statutes 51-217, specifically subsection A, not 51-217A. We left that one untouched after voting on it, and there are comments in the notes associated with that. But in 51-217 subsection A, it lists the disqualifiers for jury service. And part of our thinking in this regard was that it doesn't preclude someone from exercising a peremptory or for an excuse for cause, but to outright not allow someone to serve on a jury. In the first instance, we added that permanent residents should be allowed to serve on juries. Permanent residents are subject to our jury process, both in the criminal and civil realms, and we thought that they should also have the opportunity to serve on the jury because they're part of our wider community. And that is not only the right thing to do, we thought, but also it would expand the diversify the jury pool. We also took a look at whether felons should be excluded. The current language excludes felons for 7 years, and we would recommend that we not exclude felons at all. There was some discussion as to whether or not we should draw a distinction between those on parole and those on probation, and both of them are released. Both of them are subject to subsequent procedures if they were to be reincarcerated, and this disproportionately affects people of color. And this may be a way to expand the minority representation within the jury pool as well. And finally, just expanding the jury pool in general, we think is beneficial because it would expand the number of people from whom our juries could be selected. And specifically, we right now, as 51-217 is written, someone who's age 70 or older can they can choose not to perform jury service, and we're recommending that that be raised to 75. We thought that 70 was a little bit low, that increasing those who can opt out or decreasing the number of those who can opt out would bring more people into the jury process or keep more people in the jury process and allow for greater participation by the minority community as well as others.
Okay, discussion?
And on this one, I'm not
Can I
sure.
now on
Justice
that?
Rogers.
This is Judge
Oh,
Lamont. I'm wearing a mask because my colleague Joan Alexander has permitted me to sit in her chambers. My computer is on the fritz. I have an IT guy trying to fix it. But I wrote before to Omar and to Chase asking if this is the appropriate time to raise one issue that troubles me. That is this: I'm all for felons being restored to jury service, but not all felons. And let me describe why. First of all, I think if someone has committed an intentional murder or conspired to do it or aided and abetted or in any way been involved in the intentional killing of someone, that they should lose their right to sit on a jury forever. That is not purely punitive, and I just want to make this clear, although I think it would be okay if it were punitive. The reason is I think that all members of society enter into a certain contract or understanding. And it seems to me that arguably, at least, and I think it's true, the worst thing you can do to another human being is deprive them of life. Personally, I don't think someone who has intentionally murdered someone else should have the right to sit on a jury with other citizens and pass judgment on someone else. I believe they have lost that right and they should not be restored under any circumstance. A. B. You may all agree or disagree. I feel pretty strongly about this, but B, once you start drawing lines, you get into a question of what about a serial rapist? What about someone who murders children? What about somebody who does other kinds of horrific, horrendous acts? As I think about this, I don't see any principled, reasonable way, a distinction between intentional murder and anything else. As abhorrent, for example, as murdering children might be, or serial rape might be, or committing horrible crimes, blowing up a synagogue might be. As long as no one is killed, I cannot come up with a reasoned basis to start creating categories. And I think once you do that, then it will undermine and basically ruin the attempt to get convicted felons, to get them back in the system and give them the right to serve. But, I find it very hard to imagine that a convicted murderer, if they get out after 30 or 40 years, which I know probably doesn't happen a whole lot, or someone who aided and abetted an intentional murder or conspired, sometimes they get a deal, they get out after 20 years. I think I've made my argument. I think they have forever removed themselves from the rank of those who have a right to sit on a jury and judge their fellow citizens. So as to that part and only that part of the recommendation, I would dissent, and I might write something on that if it's appropriate.
Well, here's my question. Presently, the statute, when it restores it at 7 years, doesn't distinguish between felons. It doesn't say that only some felons get it back and not others. So what we did is our change really affects the timing, compressing the timing more than anything else. If that would be something that people would feel more comfortable with, then I would request that either this language not be approved or maybe a vote on an amendment that tried to reconcile your thoughts with what's there. But that will be a change in what's there. What's there now says after 7 years, a felon gets it restored. So making the distinctions would be something new, and be a question of whether or not that would be necessary to pass this particular proposition.
Right. Well, okay, yes. I'm done pretty much.
Can I pose a question? Is now an appropriate time? Thank you.
Yes.
So the problem I have is with categories. I mean, I don't mean to sound glib about it, but, we used to say in the trade that a murder is an assault with unfortunate consequences, or how a murder gets reduced to a manslaughter. Certainly the jury, without getting into issues of jury nullification, I mean, there are lots of reasons that juries sub down their decision, but it doesn't necessarily mean that the conduct was really any less heinous or that the actor any less venal. So I'm fine with this as it is. I'm interested in the dissent on the burden of 3 years, but we haven't gotten to that yet. But with regard to categories of crimes, I just have a hard time because I think everybody has a certain visceral reaction to certain crimes. You mentioned children. I mean, quite frankly, abuse and neglect of kids could be far more, to me, horrific than an intentional murder, depending upon the circumstances. So I just have a hard time. I could go on, and I won't. With differentiating between certain categories of crimes.
May I respond to that, Joette? I'd like to
Please.
respond. I think that I'm not talking about different categories. In fact, as I said, I don't think you can make a principal distinction. But to me, murder, taking someone's life, is qualitatively different than anything else. You've erased them from life. You've removed them from the opportunity to sit on a jury or do anything else. So that's why I am not in favor of establishing categories of heinousness. But I do think that murder is qualitatively different, qualitatively worse, and I just don't see why a murderer or someone who's committed a murder of another human being should have the right, like other citizens, to sit in judgment, even if they've served their time. I think it's qualitatively different. I think society has a perfect right to honor that distinction. Now, nobody may agree, or some may agree, but that, I've stated my view. But Joette, I'm not talking about different classifications. I'm talking about one, which is qualitatively different.
No, I didn't mean to, I apologize for my use of term categories because it's sloppy and that suggests I'm differentiating based on category. I'm not, and I didn't think you were.
Okay,
My
that's
problem
fine.
is that, no, my problem is that, again, when something comes in as a murder and goes out the door as a manslaughter, I'm not sure it is different from the standpoint of what you're talking about.
Well, then maybe we should include manslaughter too. But that's not an argument for not including intentional murder. That's just, Joe, by the way, Joanne and I spend hundreds of hours together on our committee, and so we can discuss these matters. But I've made my point. I don't know if anyone agrees, but I've made my point.
May I make a point? This is David Gold. May I ask a question as well?
Yes.
Thank you.
Yep.
Am I then to understand that the only people that would be excluded under the proposed change are people that are actually in jail at the time?
That's correct, Your Honor.
So
People that are actually somehow in detention.
So everyone else, regardless of how recently they were released, would automatically be eligible.
That's correct, Your Honor.
I might add, Your Honor, that there was a debate in the committee whether it should be custody or physical custody.
My
position was it should be physical custody, but the language we voted on was this.
All right. I mean, I don't know many. I'm not aware of any situation where someone actually received jury notice and was brought over to the courthouse. So really, no one is being. This won't really exclude from service anyone that would have actually appeared. Is that right? Thank you so much.
You're probably right as a practical matter.
Okay. Now, the question I have is this, and it's tied to the subcommittee that I was on. I know that Mr. Lohr, in his remarks, said that this did not in any way limit the exercise of peremptory challenges of a person who might fall in this might fall outside the exclusion, but perhaps would have fallen under the rule as it existed. But in fact, the proposal that's coming out of my subcommittee indicates that one's prior experience with the criminal justice system in and of itself cannot be the basis for is presumptively an invalid reason to excuse someone from through peremptory challenges. Now, it seems to me that to suggest that a person who had committed a serious crime could serve and not be subject to peremptory challenge is an inappropriate end result of this change, if it is to be incorporated along with the revised Batson process that's coming out of my subcommittee.
There might be a need then to reconcile that with a distinction between, and I guess we're getting into categories, someone who's actually been convicted of a crime, of a felony, and has their jury service restored, as opposed to someone who's had an experience with it and the like. I did talk to Judge Levine about this while we were considering it, because that was a concern of mine, that the two might be in conflict. I don't think it would be fair to categorize this as a non-race race neutral reason. But we're not talking just about the criminal system here. There's also civil system. So a juror such as that might be perfectly acceptable in a civil situation, but not to a prosecutor. But then again, a prosecutor may want that person on there.
I agree completely, but our proposal for the Batson revision is going to be equally applicable to criminal and civil cases. But I think it is ill-advised to have in place a rule that might require the seating, that would presumptively require the seating of a juror with a significant prior dangerous felony record, just because that's the only reason that a party might seek to excuse that juror peremptorily, because the rule that's being proposed would presumptively render that an invalid challenge. So I think Harry's idea that there may have to be some effort to reconcile this sub 2, or maybe actually our rule would have to, but this gets dicey.
Yes, but I think this can be important. If we're going to adopt a rule that's going to close the gap and at least allow these people to be invited to jury service, not automatically exclude them, which we talked about this a lot in the subcommittee, the idea of getting the people to the courthouse is one thing, deciding whether they should serve is another. But definitely I'm concerned about the fact that making it a non-race neutral, a presumptively non-race neutral peremptory would be harmful. I am worried about that. And if the two can't be reconciled, now you'd still have to reconcile that as well, because if someone had it restored after 7 years, you'd still have a convicted felon that might want to serve on a jury. So I think there's going to have to be a need between someone who has a relationship between the criminal justice system and someone who's just served as a convicted felon. If those two things can't be rectified, then it leaves us as an interesting place, because they would still have to be reconciled, even if the statute is as it is.
That's a fair point.
Yeah, they still have to be reconciled. So this proposal is designed to get people to the courthouse, not to exclude them automatically, and then let the process itself work itself out. And maybe then, if this is going to be passed, it has to be with an understanding that your subcommittee's proposal is going to be somehow modified.
Well, the idea of speaking at greater length with Joette and Doug is something I just can't tell you how much I'm looking forward to.
Okay. Dan, were you trying to say something?
I was, and I realized several people have raised their hands electronically. I don't want to jump ahead of them, so I'll wait my turn.
Okay, again, I can't see a lot of.
I know.
So...
Matt Blumenthal had his hand up electronically, and a couple other people.
All right, Matt.
I was just going to say basically what Harry did, which is that conceptually, at least what our proposal does is it doesn't say that these people can serve, it just gets them in the door. And then instead of treating them categorically based on their conviction or the quality of their conviction, it allows the lawyers and the judge to decide based on the specific facts of that person's experience with the criminal justice system, whether the case is one that's appropriate for them.
Thank you. Who else?
I see Attorney Rapillo has her hand up as well.
Yes, I mean, a lot of what I had wanted to say has been said, but I did want to state that I don't think that any category of crime ought to be excluded, because once you start doing that, it does, I mean, just in the conversation, it sort of opened up the doors for people's subjective opinions on what's heinous and what ought to qualify somebody to serve. So this idea that everybody gets in the door and then the court through our process will work out who serves and who doesn't serve is the right approach.
Attorney Preston. Who else?
Okay, yes. This is Preston Tisdale. My comment is a couple things. Number one, we have to remember what we're here to do. So we're not here to make it more restrictive than it already is for persons to serve. We're here to address a racial imbalance. So anything which is looking to make it more restrictive is counterproductive to what we're trying to accomplish. Number two, we also need to keep in mind the broad parameters. You know, we can't be ignorant to the overarching circumstances in society. So every study shows that Black males are more likely to be enmeshed in the criminal justice system than a comparable white male. They're also showing, all the studies that show, to receive harsher sentences, controlled for virtually every variable, than white males. And we have to keep that in mind. I just go to point just one simple study. For years, I've been the chair of RISAP, that's based in Fairfield County, and it focuses on the Fairfield JD. And every 2 years, they come out with a survey which shows that more youths, suburban high school age youths, are engaged in substance abuse than urban high school age youth. And they've been doing this study for the last 20 plus years. And yet you can go into GA2 and you will see it comprised of primarily 80 to 90% individuals from urban areas, which means that they will be Black or brown. So we just cannot lose sight of those facts as we endeavor to eliminate the inequities in jury selection and certainly in jury summoning.
Thank you. Anyone else?
So Preston said most of what I was going to say more eloquently than I would. I would just add historically, statutes that excluded felons from jury service were aimed primarily at keeping Black people from serving on juries as a proxy for that. Some of them existed at common law beforehand, but it's one part of the way that racial imbalance played out in the justice system. If the end result of all of this is that more people who have paid their debt to society serve on juries, that strikes me as a good thing.
And I think that's exactly what our goal is.
Anybody else?
Rogers, I'm not sure if, once the discussion is done, whether you wanted to go and vote on each particular proposal and then move on to the next statutory proposal or the whole package. I leave that up to you.
And it seems to me, because it's fairly substantive, that we should do each separately. How do you want to proceed on this one? Do you want to have further discussions with your subcommittee and talk to the Batson committee a little more, and then we'll get something out in writing to the full committee for a vote, or do you want to try and do it now?
I'm not sure either way. I got the impression, talking to Judge Gold, that maybe that's something that is already would be taken into consideration. But if you would prefer that we wait on that until we're assured that there's an understanding, then certainly we can take care of that in the next week.
Why don't we do that? I think that makes sense.
So it'll be like tabling this for now.
I'm sorry?
It'll be like tabling this for now.
Okay, right. We'll table it for now, and we will get something out to everybody so that hopefully we can move ahead with it and get their votes up.
Chief Justice,
Okay.
I just need to say one quick thing on this point also.
Yes,
With respect to, thank you. With respect to the interplay between this portion of the proposal and the potential preclusion from using a peremptory to exclude somebody because of their prior criminal history, that I think it's important to remember, practically speaking, that as long as we have peremptory challenges, as pessimistic as this might sound, it always leaves an end run around any other rule that we make. And just in the same way that people de facto repeatedly exclude people of color from serving on juries by saying, I'm using a peremptory because this potential juror has just shown such rapport with the other side, or any one of a number of race-neutral reasons. The same can be said for someone using a peremptory challenge and citing a criminal history neutral reason. So as long as peremptories exist, I think we will still have a potential end run, whether it's something related to race or criminal history. So I just wanted to make that brief point. Thank you.
Important point. Okay, so we will table that one. More to follow on that. And then are we on to 51-220 then?
Well, David Gold, I think, wanted to say something.
Yeah, I'm sorry. I can't. Yes, David, you'll just have to yell, folks, when you want to talk.
All right. Well, no, I just wanted to the extent that this is being tabled, to permit my subcommittee to further consider whether there should be exception added, I would not expect that there is going to be agreement to modify anything that we have agreed on. So there will be, I suspect, every reason to think that the Batson rule that comes out of our subcommittee based on the Washington rule is going to make presumptively invalid any peremptory challenge based on a juror's personal experience with the criminal justice system, or the juror's knowledge of relatives or friends' involvement in the criminal justice system. I would not anticipate there would be a sufficient number of votes to alter that. So I'm just saying that to the extent that you're expecting it to be tabled, your proposal to be tabled, anticipating that the subcommittee that I'm on would likely to affect a change in what's been proposed so far, I would expect that to be unlikely.
All right, where does that leave us?
Well, it leaves us with the fact that even now, it's just a question of how many years we're talking about. A convicted felon now can serve on a jury after 7 years. Whether that compression of time makes a difference. I have to admit that, yeah, I am troubled by it, but this is the recommendation that the subcommittee proposed. I would probably prefer, and I don't know how Esther or anyone else on my subcommittee feels, I probably prefer thinking this one over just a bit, but we still have the first proposal on the changing it to permanent residence. And I don't know if we'd want to vote on that or just wait and vote on 217 as a package.
Let's do 217.
I'm sorry, Chase, I beg your pardon.
No, I was just going to suggest that we do 217 as a package, because the point is that we're trying to get it to the folks that need to push it forward. So we might as well have it as a package, and certainly we'll give you more time to think about it.
Yeah, I'm of the view that we probably won't change our position either. So because I think everybody agrees that getting the people into the system is better than not. But if the system isn't going to bend on one side or the other, then we might be at a point where we're being counterproductive. So let us think it over a little more.
Okay.
Might I ask one question about the permanent resident provision?
Sure.
It's pretty straightforward. Is there, I don't know what the Connecticut constitutional provision says with regard to the jury, the composition of the jury. Is there anything in the Constitution that speaks of citizens or anything like that? Or has that already been discussed?
You have to be a citizen to serve.
No.
So constitutionally, do you know, Harry, or anyone?
I have to recheck that. I thought I did that.
I just want to make sure it doesn't require a person to be.
David, that would be embarrassing if we missed that.
Well,
I'll take a look at it. Since we're tabling this, let me make sure. That would be an embarrassing oversight.
My recollection was that there was no such restriction, but we should double check.
That's great.
All right, that was my only point. Thank you, Chase.
Yep. All right, so we move to the next one.
Yes, that is Matt will be talking on General Statutes 220. Matt.
Sounds good. Thanks, Harry. So I'm going to be presenting on one of two legislative proposals to solve essentially the same problem. Bill Bloss is going to present on the second one. But before I go through the problem and our proposed solutions, I just wanted to note that the subcommittee recommended that both policies be recommended to the legislature. We did so unanimously. There was one dissenter on the specific legislative language for the proposal that Bill is going to present on, and I'll let the dissenter speak to his own concerns at that point. So the problem we were trying to address is one that we all understand. The constitutional demand or obligation on the judicial system is in creating a veneer is to present a fair cross-section of the community. And the General Assembly's policy for accomplishing that obligation currently is proportional representation by geography. And it's by town in the current statute. The way it's laid out currently, statutorily, is that the branch is directed to send a number of summonses to each town proportional to that town's share of the population of the judicial district. So if there are 2 towns in the judicial district, town A has a proportional share of 1/3 of the population, town B has a proportional share of 2/3. 1/3 of the summonses are sent to town A, 2/3 are sent to town B. The confound that interferes with an actual fair cross-section of the community under our current statutory regime is that there are undeliverable summonses and that some prospective jurors don't show up to jury service, to jury selection. And as one might predict, the rates of no-shows and deliverables are different in different towns. And this has important implications for demographic representation in the veneer. Most importantly, distorts it in ways that are predictable and in ways we're trying to correct in this task force. So around the country, other states have experienced these problems, and jurisdictions have taken differing approaches to try to solve it. Some jurisdictions have tried to adjust the veneer with direct attention to demography, so by race, ethnicity, et cetera. There have been some arguments that this could be constitutional. Some people on our subcommittee thought perhaps it might not be, but such a policy would clearly have constitutional implications. On the other hand, addressing this problem by geographic oversampling has no constitutional problems. And we've done some research on this that confirms that there is no authority indicating that geographic oversampling, again, race blind, ethnicity blind, that there has been no authority that has found geographic oversampling to create the veneer to be a constitutional problem. And I'm happy to send the OLR report around if anyone would like to see it. So we've got, again, 2 proposals. One is more comprehensive, that's the one I'm presenting on, and then one is a bit more targeted just to undeliverables. That is the one Bill is presenting on. So in section 52-220, the change that we've recommended is essentially one that takes the General Assembly's policy and just informs it with data. So currently we kind of blindly send out a proportional number of summonses to the town, irrespective of that town's actual yield in the veneer. So if a town is underrepresented and based on undeliverables and no-shows or other issues that are going on, we're not taking that into account. What the recommended change to 52-220 does is, instead of just sending out those summonses without taking into account an individual town's yield, it collects data on each town's yield and reconstructs the number of summonses that should be sent to that town so that it's one that we would predict would create a proportional representation for that town. And as we noted in the discussion, there are kind of 2 proposals for which data set to use, whether it should be the previous calendar year or it should be multiple calendar years in advance. The previous calendar year would be more responsive to any improvements. But again, there may be administrative or other issues that may make the multiple year proposal more attractive. So anyway, we're excited about this proposal. We recommended it unanimously, and I'd be glad to answer any questions that anyone may have. I'm not hearing anything. All right, well, either I did a great job explaining it, or I just confused everyone. Either way, if you have questions that you want to ask later, I'm glad to answer them. And just to put you all at ease, I know having the formula spelled out in words makes it a little intimidating or confusing. I did check with someone who is an expert in math that it achieves what we mean it to achieve. So I can give you that assurance.
Can I just add
Go ahead.
quickly? So I'm sure you all discussed this, the burden on whoever is going to have to be, number one, providing this information, and then number two, on whoever's figuring out what this information really means. So it wasn't totally clear to me. I mean, is the primary burden now going to be on the jury administrator, or is it the towns? And if it's either one or both, you all are comfortable that this isn't something that there's going to be like freaking out that there's no way we can do this?
So thank you for the question. So the burden, the administrative burden, would be on the administrator. My understanding is that the branch already has this data, and if there are any issues related to administrative burdens and costs or anything, that is a question that should be addressed to the legislature when it's recommended, and the legislature should attempt to provide whatever is necessary.
Good luck with that, having been on the other side of that discussion.
But
okay.
it is basically the data already is collected, and it would be simply a matter of applying the formula to determine the new number of summonses that should be sent to each town.
Okay, thank you. Okay, anybody else?
Yeah, I just wanted to point out that after the work on this, which when I first saw it, I thought was an incredibly creative idea, having done a lot of work in litigating the jury issue. I don't think this has been tried anywhere. I think it's revolutionary, and and constitutional. We do have a system now that is completely in keeping with the Constitution, but I think it was something actually that Matt might have said early in the process, that just because it's constitutional doesn't mean we can't make it better. The system has very little control over the reasons why we lose a lot of jurors. This is one way up front to say, okay, we understand that we lose jurors because of undeliverables and stuff. This is what the system might be able to do at the outset to try to improve that yield. It really is a remarkably, in my view, creative way of doing it. And we might be the first to ever try it. And Matt's work on it has really been quite remarkable.
That's great, thank you.
Thank you, Harry.
All right, so do we have further discussion on 220, or can we vote on that one?
Are we voting on which of the, let me just say at the outset, I think it's a fantastic idea. If Harry thinks its constitutionality really isn't in question, I think it is creative. It's a tremendous, I can't believe nobody's tried it before. It's a great idea. But are we voting on whether it would be 1 year or 3 years, or just the concept generally?
What we're trying to do is the concept generally, as our discussion and our rationale makes clear, it probably would be best to have this go into effect in 2 or 3 years, so that we're actually consciously gathering the yield data for the process of effectuating this. In the meantime, between now and then, the next statute, which Bill Bloss will discuss, would be like a stopgap measure to try to create some way to compensate for undeliverables. So they're not exclusive, they're complementary. First comes the change that allows, that Bill will discuss, and then this statute would be, the effective date of this statute would be either 2 or 3 years down the road.
Chief Justice Rogers, could we maybe hold off on voting on this till I hear Bill Bloss's part of it, and then maybe it can be looked at as a whole?
That makes sense.
Absolutely.
That makes sense.
Okay, should we move to the next one?
Yeah, Bill Bloss will be discussing that.
Okay, thank you. This is the same issue. The only thing I would add to what Matt raised is that when an undeliverable summons comes back, a new summons is sent out at random to any town in the JD, so that statistically, if it is true that undeliverables and no-shows tend to be a bigger issue in poorer communities and communities of color, then statistically the new summons is likely to go to a non-minority in any JD, which is not majority minority, which is every JD. So what this proposal is not something that is brand new. In fact, it's a part of many jury plans around the country. This is called targeted replacement mailing, meaning that each time you get an undeliverable, it's replaced by a new mailing to a randomly selected address within the same zip code. This has been around for many years. It's been proposed by members of the National Center for State Courts. The federal court here in Connecticut has this as part of their jury plan. Massachusetts, Kansas, several other federal courts. The Northern District of Illinois has it, and they actually did a study in 2018 that said that, along with some other reforms, that this has had considerable success in increasing jury diversity. But just to be candid, it probably is more likely to be successful in the larger JDs and where there are concentrations of communities of color, and then a large number of majority potential jurors outside the particular area. So that's it. It's not much more complicated than that. I think the only question might be whether do you define non-deliverables mean as only summonses that are returned by the Postal Service as not being able to be delivered, or do you include non-responses, people that just don't respond to the summons? Do you include them as well? Because that's more of an issue in communities of color demographically.
And did you all discuss that internally and decide which way you wanted to go on that?
I believe our discussions are focused on undeliverables. The reason is the no-shows, you really don't know who they are until it's very late in the process. So you're kind of not, anything that's delayed in the process, in the summoning process, really doesn't correct for the problem you're dealing with. Where undeliverables is knowledgeable. The issue, the problem that I foresee is right now, from what we understand, and Esther, please correct me if I'm wrong, this new system will be using the NCOA, National Change of Address process. And therefore, if a summons is addressed to somebody and the National Change of Address system knows that that's a bad address, the present system will be able to immediately say, we can't send it to that because the new address is outside the jurisdiction, or here's the new address within the jurisdiction. If it's someone who they can't resend it to, then automatically the system should be able to randomly select someone in the same zip code. The problem I foresee is a lot of the non-deliverables are outside the NCOA. They're just going to come back in bulk, and we're going to have to address that. But the concept of doing this again at the front end and not the back end, not saying, gee, I don't like the makeup of the people who showed up, so I'm going to now send out more summonses. We're really doing this in the front end. It's not directed in the same manner. That's why I think it's constitutional. And we, as a committee, think it's a good solution until we actually do this overhaul of the process.
Okay, further discussion? I'm not seeing anything. All right, is this one then that we can vote on, it sounds like? And it would be 2 statutes.
220 and 232, 51, 220.
Right, 51-220 and right, 32. Can I have a motion to approve?
So moved.
Second?
Second.
All right, all in favor, vote aye, please.
Aye.
Aye. Aye.
Okay.
Aye.
Any nays? Okay, hearing nothing, those 2 can move forward. Right here, you got another one, right?
Yeah, the last one is 51-247. I'll present on that. I think it's pretty straightforward. We got to pay jurors more. We haven't done it since 2007. Inflation and the effect of low pay certainly has an effect on people who are poor and also those who work for a living and might not get paid after the first 5 days, or certainly not get paid enough in order to serve on a jury. So what this does is three things, two major things. It connects the payment of your jury service to the minimum wage. So it doesn't have to be, you don't have to keep revisiting this like 10 years later. You won't have to go back and revisit it. If the minimum wage is now $11 an hour and it's based on an 8-hour day, jurors will get paid for that. It does advance when jurors will get compensation, part-time workers and unemployed, to make sure that they're paid from the beginning. And along with this will be a recommendation coming in our final process of how we maybe adjust the summonsing and provide information to the public that makes it clear to them that they're going to get paid. The other thing it does is it puts a statutory reference to childcare. Presently, childcare is paid for to people who qualify. I believe, Esther, correct me if I'm wrong, it's $20 to $50 a day. We want to leave that in the discretion of the jury administrator as to how that's effectuated. So what we're doing is we're paying more for mileage, we're paying more for jury service, and we're making sure that people know that childcare is something that they can be compensated for. And the hopes is this just make it easier for people, especially people who are day workers and people who are poor and single mothers who serve on juries, to be at least available for juries, because we know that these are reasons that people sometimes don't even respond, let alone don't serve.
I have a question. If I may, did you all,
Yes.
in terms of childcare, unfortunately, we're moving into the age where people no longer have children to care for, but they have elder parents to care for. And I was wondering whether or not that was something that had been caretaking responsibilities regardless of age.
We did not discuss that. Esther, do they pay for that? Is that considered in one of the cares that the Judicial Department pays for? We didn't discuss it.
Yes, it does. The reimbursement piece that you mentioned before. Can everybody hear me?
Yes.
Yeah.
Yes.
Okay. I thought I was muted for a minute there. The reimbursement issue that you mentioned before, which is $20 per day but cannot exceed $50, applies for family care, elder care, not just child care.
It might behoove us then to add to just take out childcare and put family care as a reference, if that would be.
If we could use the language that is currently in the handbook, because it does discuss that in the juror handbook. It does talk about that. So if we want to use that same language, we can do that.
And that language is what, family care?
Yes. It talks about family care and child care to be reimbursed.
Yeah, I would accept that as an amendment.
Okay. Further discussion? All right, can we vote then with the amendment that there'll be a change to family care as opposed to child care? This is 51-247. Have somebody move, please, to accept this one.
So moved.
Second.
Second.
All right, all in favor, vote aye.
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 Any opposed? All right, hearing nothing, that one can move forward as well, and it's been approved, right?
No,
Is
Your
that
Honor, what do you
it for
want to do
yours,
with what do you want to do with 51-271? Do you want us to just reconsider it and then propose it and we'll discuss it in another meeting?
I think what we're gonna try to do, we can talk about this on, but I think what we'll try to do is move it forward. So you all figure out what you want to do, and then we'll submit it in writing to the full committee and get votes on it, so that we'll be able to get this package to the branch, if that's all right.
I'm not sure maybe you and I can talk and we can just.
Yeah, we'll talk afterwards. Let's do that. All right, that's fine. And by the way, it's the judicial branch, Harry. You know that, not the judicial department.
Nah, I'm retired. I forgot all that stuff.
All right. Okay. For the two committees that reported out today, thank you. This is really fantastic work, and I think it's going to advance the ball as to where we're trying to get. So, Judge Levine or Judge Gold, do you want to give a quick update or anything that you want to discuss with regard to your implicit bias subcommittee?
Yeah, I'll start, but basically we are turning around the final bend, or whatever the expression is. We have basic agreement on, we have 3 subcommittees, and we have basic agreement on all of them, except we're tinkering around with a little bit of language on an introductory statement to the one relating to Rule 37. But we've put in a lot of time, Joette, myself, Dave Gold, the other members of the committee, and we've come up with a proposal that is basically going to be unanimously approved by our committee, and we expect to get it to the whole committee or the whole task force very, very soon. Dave, I don't have a whole lot else to add, but Dave, you want to add anything?
No, I think that summed it up fine, Doug. Thanks.
Okay, great. That's great. Thank you. So I just want to make sure that everybody's aware the next deadline that we've got is December 2nd, and that would be the deadline to submit any final proposals over and above the legislation that we've already discussed today. We will take a look at all of that and then get it out to all the committee members. And then on December 16th, we will have the proposals reviewed and hopefully approved, and get them to the Chief Justice and the Chief Court Administrator. And hopefully all of your hard work on this will be completed at that point. Is there anything else, questions, comments that anybody would like to make before we adjourn?
Just a question on the final proposals. Do you want that in a report, much like this was presented?
Yes, and then we were actually talking this morning, we will be putting the full final report for the Chief Justice together, but to where we started on this months ago was as much work as you all can do would be greatly appreciated, because as you well know, the judicial branch staff that's been assisting you are very busy trying to get these courts open and continuing to operate. So as much as you can do would be greatly appreciated. All right. With that, I want to thank everybody. Judge Williams, do you have anything that you want to add?
No, other than just being floored by how innovative and effective these recommendations are. This is outstanding work. It's unbelievable. Thank you.
All right, Harry, you want to stay on, and Judge Williams, and maybe we can talk about this a little bit as to how we'll go forward on the one statute. Okay, great. Thank you, everybody.
Thank you. Be well.
Well. All right.